Fantastic. Excellent. Thank you very much. Right, everybody. Okay, let's get started. Hello and welcome to this East Sussex Resolution seminar on indecent images. The East Sussex Resolution Committee has arranged for a stellar panel of experts to provide you with this seminar. And I would first like to take you through the panel and provide a short intro to those on the panel. I'll start with myself as host. I've been clerking for over 20 years, and in 2022, I took up the position of Deputy Senior Clerk at Westgate Chambers. I am a member of Resolution, and I sit on the committee of East Sussex Resolution. I've been recognised in the Legal 500 and Chambers and Partners for client services at the bar, where it was commented that Stuart is friendly, conscientious, and has a clear willingness to accommodate the needs of those instructing. He often goes above and beyond what is required. I must remember to pay those people who said such wonderful things. We have with us also James Evans from Our Family Wizard. James is the head of UK professional education at Our Family Wizard. Having previously worked as a teacher, James joined the family law community over 5 years ago to introduce family law practitioners around the country to Our Family Wizard. James works with courts, chambers, firms, CAFCAS, mediators, organisations and charities to help parents with their communication. James has been shortlisted for over 10 awards for his contribution to innovation and championing the support of separated families, and recently won the Working in Collaboration Award at Resolution's 2023 Family Law Awards and Innovation in Family Law at 2023 Family Awards. Stephanie from the Carvalho Consultancy is also a member of our expert committee and panel. Stephanie is an experienced integrative psychotherapist and executive coach registered with the BACP. She became a psychotherapist and executive coach after 8 years at the criminal bar and 4 years as an employed barrister working for the government. She has worked for a wider range and variety of people from all walks of life, with many different reasons for coming to therapy, both in the NHS and in private practice, and have conducted research into psychological toll on barristers of conducting rape and sexual assault cases. As an integrative practitioner, she is trained in several different theories and therapeutic modalities, including the humanistic and psychodynamic approaches and cognitive behavioural therapy. Ayisha Robertson is a member of Westgate Chambers. Ayisha is a family law specialist who was called to the bar in 2016. Her background in education and psychodynamics means that her practice lends itself to working with children and vulnerable clients. And she is regularly instructed to represent clients with learning difficulties and recognised psychiatric disorders. Ayisha is also a co-host with other members of Westgate Chambers of the popular Family Law Week podcast. Clients comment that Ayisha is fantastic, and her friendly and approachable manner puts clients at ease from the get-go. When representing her clients in court, her thorough and robust advocacy style continues to showcase her clients in a way that is well received by the judiciary. We have Delia Monoprio with us today, also from 1 Crown Office Row. Delia is working and has been working in family law children since 2005. She tells me that she's not interested in self-promotion today. And what she would most like you to know is that her main joy in life is her boxer dog, with whom she is obsessed. She also loves to bring joy and making people sing songs and cook delicious food. That sounds fabulous, Delia. In terms of our batting order, we will first start with James Evans, who will speak about Our Family Wizard and its exciting new features for 2024. Stephanie will then speak first on the lay-client and family lawyer relationship and what you should be looking out for as family practitioners when the clients are dealing with trauma. Ayisha will then follow, and Ayisha will speak on case law and what family practitioners should be aware of when dealing with cases that have indecent images. Delia will then follow, and Delia will speak on what she feels to be are the top tips for family law practitioners when dealing with cases that have indecent images. And then we will come back to Stephanie to finish our seminar, where she will discuss how do you cope as family practitioners when you are dealing with cases that have indecent images. I think that's a really important topic for everyone here. Finally, 2 points. I'd like to thank, on behalf of East Sussex Resolution, our sponsors, Westgate Chambers, Our Family Wizard and 1 Crown Office Row. Without their generosity, we are simply not able to provide these seminars for free. So thank you to all of those. And finally, a little bit of housekeeping. Please do ensure that you are muted. And whilst we would love to see your faces, we will not take offence if your cameras are turned off. The chat function will be in use for questions, which I will moderate. Questions will be answered at the end of the seminar should we have time. Finally, please be reminded that today's seminar is being recorded. The recording will follow with any handouts that have been provided by our experts. So let's get started, shall we? James, over to you.
Thanks, Stuart, and thank you very much to everyone involved for inviting our Family Wizards to sponsor today's webinar. I'm also a member of the East Sussex Resolution Committee, so any work that we do with that region is always something that's very close to my heart, so delighted to be here. We're obviously talking about a very, very important topic today, very sensitive topic, and something that our Family Wizard is passionate in when it comes to supporting and helping the families that you work with. I'm going to start off by sharing my screen. Stuart, can you confirm that you can see my slides there? Do they look good to you?
They look great.
Thank you. So for those of you who don't know, our Family Wizard, we're a co-parenting communication app. We offer a safe space for parents to communicate before, during, or after the divorce and separation process. Now, our Family Wizard was built to help facilitate and better improve child-focused communication for parents, but it's also a safe platform to provide security in an online communication world where it is very dangerous and risky. We are working in more and more cases where fake text messages are being generated, fake emails, fake WhatsApps. This is something that is very, very easy to do and is very quick to learn how to do and free online. We worked a case last year where they used a website called iFake. That's the website you're seeing in front of you now, where it allows you to generate a fake text message and send it to yourself on your phone. So in this case, the ex-partner was called, we've changed the name, so let's call them Jamie. They typed out the message they would like to have received from Jamie, and then personalize how that message will look on their phone. So it's things like, what was their battery percentage? What was their signal strength? Who was their network with? Did they have airplane mode turned on? Was Bluetooth turned on? And what type of message is it? They then generate the image on this type of website and get it sent to themselves on their phone. And these websites make it look like it's come from that person in your phone book. It's horrible, it's nasty, it's malicious, it's scary, but this type of thing is free and it's available to anyone with access to Google. You can do this with WhatsApp, email, text messages, any type of online communication platform you can think of. So when we're talking about indecent images or any sort of online coercive or abusive situation, it is really important that you offer a safe platform for your parents to facilitate communication. That's where our Family Wizard comes in. We have a host of features that have been dedicated for the needs of separating parents, including one of our brand new features, which Stuart mentioned. We've got a message board where parents can send each other direct messages. However, these are different from other types of message board they use because they are time-stamped. Who sent the message, on what date, at what time, and crucially, who first viewed that message, on what date, at what time. Those timestamps cannot be edited, deleted, or turned on and off. When they are messaging each other, it includes something we call tone meter. Tone meter is like a spell check for your emotions. So if one parent is drafting a message to another, it will alert to that parent as they're drafting the message of any language they've used that might be considered offensive or inflammatory. The example we have here, "Why are you so bad at being on time?" could be read as aggressive by the recipient parent. It's an early version of AI and it does help a lot of families focus their communication and improve that behavior. We have one of the most vast and dynamic co-parenting calendars you can find online. It is fully color-coded and gives the parents lots of opportunities to get into the details of their co-parenting calendar. We give them an option to put in a parenting schedule, for example, using some of the most popular templates we see, but also give them an option to create their own custom schedule. But if they need to make changes to the schedule, they don't need to call each other and go back and forth. It's all done within the calendar feature. They make requests for changes, and as with all our other features, everything is logged. Who did what, on what date, at what time is permanently recorded. It puts full accountability on the parents. And as a result of that accountability, their behavior tends to improve. We have a journal where we allow parents to upload pictures and videos, but they can do so without interactions and there's no social media involved. They can only have a look at that picture, but if that parent has chosen to share it with them, it is all done through consent. They can even share their location. If they need to evidence they were in a certain place at a certain time, they can drop the pin in the map and timestamp it without tracking each other. This is our brand new feature. It comes out next month. We're literally 2 or 3 weeks away from this being launched. We are introducing calls into our Family Wizard. Parents will be able to make voice and video calls within our Family Wizard. However, this is going to be done without the use of phone numbers and email addresses. Parents will call each other through the app. They don't need their phone numbers, and they will be able to video call each other within the app. They don't need their email addresses. This is all done through consent. Who called who, on what date, at what time? Did they consent to that call? And this is all logged. How long was the call? When did they accept? When did they hang up? That kind of thing. This is coming out very soon, and we are extremely excited about it. We have an info bank for parents where they can store information about the family, things like health information, medication, allergies, prescriptions, family vitals, shoe size, trouser size, that kind of thing. And they can store documents in the system. And lastly, parents have access to an expense log, simply a space to log those payments. Who owes what towards the child? It's all nice and neatly color coded, and they can upload screenshots when they do this process. Nice, clean, clear, and accountable. Family law professionals like yourselves can also have access to our Family Wizard. We offer what we call professional accounts that allow you, with the consent of your clients, to link into their accounts, overview their activity, and turn all of this information into court admissible reports for free. So if you are going to court and you need to evidence anything within our Family Wizard, you can do that with each of our features, with the messages, the calendar, the journal, with the call activity log, and the expenses. You also have access to the sign-in history. So if you need evidence that one parent is not logging in as much as the other, you can do so. There are, of course, free apps on the market, co-parenting apps and other types of apps. And we ask that you do your research. If another app comes up that you haven't heard of, please just have a quick look online before recommending them. No co-parenting app has as many features as our Family Wizard. We're the only one with free 7-day-a-week customer support and with a UK entity. We do not let users stay logged in indefinitely. They must log in with their biometrics, which is their Face ID or their thumbprint, every time. It's all about security. And free apps are not GDPR compliant. They make your money by selling your data. And of course, we all know what happens with data sales. That is not something our Family Wizard do. We are GDPR compliant. We are the only co-parenting app that facilitates that. And we do not allow them to delete the data, which free apps do. So please just do your research. Now, our Family Wizard is a subscription program. It costs £79 per parent per year. They pay once at the start of the year, and then that is an annual subscription. And those costs are there for the reasons we just mentioned. We are not selling data, and that money is going back into the parent security. We are very proud that in our 23 years of international existence, we have never been hacked. Touch wood. As far as I'm aware, no one's hacked our Family Wizard in the last 15 minutes since we've been on this call. However, if you are working with a family who are on low income, benefits, welfare, legal aid, universal credit, job seekers allowance, any sort of financial support, then our Family Wizard is free. They do that by completing the form you can see here, which you can get on our website, or accessing a 2-for-1 account if they are an active or retired members of the armed forces. So if they need our Family Wizard for free, they can always get it. We're also extremely proud to announce the launch of our new parenting plan that we've written in collaboration with the National Association of Children Contact Centres. This is a free-to-use universal parenting plan. They don't have to be using our Family Wizard to take advantage of this. However, it does link in with all the features if they choose to. You can download it on that QR code, or we'll send you the link and you can find it on the NACCC's website. This is a clear, easy-to-use parenting plan that is concise, usable by any party, and is very much child focused. We encourage you to have a look at this and use it with your clients where you see suitable. If you're working in the court sphere, then our Family Wizard can be used there too. We're delighted to have a court order language that has been written for us by the judiciary. If you are in the process of going through the courts with your clients, then you can put our Family Wizard into a court order. This is a template that was taken from the standard orders. It's a section 11.7 order, and it has stipulations in it stating that both parties will subscribe to our Family Wizard, how to use their communication, focusing it within the child, and putting in certain variations. So specific needs like the calendar or the messaging. You know these clients better than us. Use this where you need, and you can put yourself in the order as well too. If you want to know any more about our orders, then we have a mountain of court orders that we can share with you with redacted language to see it in action. We're so delighted to have a partnership with Resolution, both regionally with East Sussex and nationally across the country. As mentioned, we were honoured with winning the Working Collaboration Award by Resolution last year. And Resolution have provided us with this testimonial stating that our Family Wizard encourages parents to have more amicable communications, putting the focus on the child. If that's one thing to take away from today, that is what our Family Wizard is trying to do. That's me, and that really is, that's still 6-year-old me there. That's me putting the focus back on the child. So if you have any questions, if you'd like more information, please do jot down my name, my email, or drop me a message in the chat. We offer free CPD training sessions we can do online or in person, and we are here to help you with your clients. If you have any more questions, please do get in touch. That is it from me. I'm going to stop sharing my screen and remove my pin, and then I'll pass it off to Ayisha.
Hello, good afternoon, everybody. My name's Ayisha Robertson. I think Stuart's introduced us nicely. If I'm correct, I think actually we might be going to Stephanie first. Is that right, Stuart?
Yeah,
Sorry.
that's okay. Absolutely. Thank you, James, just for that. That was excellent. Our Family Wizard and the NACCC parenting plan. Your other video and voice calls and those other exciting features for 2024 look great. So yeah, congratulations and thank you for your continued support. Stephanie, we are coming to you. So as I've discussed, Stephanie sits on our panel for this event. Stephanie will first speak on the lay client and family lawyer relationship. What should you be looking out for as family practitioners when your clients are dealing with trauma? So again, hopefully this is really helpful to you all. Over to you, Stephanie.
Thank you. Hi, everyone. So what is trauma? Trauma is an event or a series of events that are so stressful, frightening, or distressing that they overwhelm our brain's ability to manage or assimilate the emotions we experience in connection with the event. So it might be childhood neglect or sexual abuse, a victim of a violent crime, or experienced coercive and controlling behavior, or loss. It's important to remember that one person may find an event traumatizing while another does not. So people will respond differently to the same event and might be affected for a much longer period of time. So, for example, you and I are both involved in a car crash. We both find it scary and distressing. But for me, for whatever reason, the emotions get stuck while you come to terms with the events and you move forward. You might think about it occasionally, but it doesn't get in the way of you living your life. Whereas for me, I get flashbacks, I can't drive, I find myself becoming easily preoccupied with understanding how the crash occurred. I'm irritable and I can get down easily. And so something's kind of stuck. My brain hasn't kind of processed the experience. The body's response to trauma can continue long after the situation's concluded. So, for example, a survivor of sexual violence may recoil at being touched in a certain way for a very long time after the traumatic event. Might experience intrusive thoughts. So, the horrifying image pops into your brain at the most inconvenient time, at random, which can be extremely debilitating to live with. In fact, early life traumatic experiences, especially, have been shown to physically leave their mark on the anatomy and the physiology of the brain. So there are physical scars that affect the brain's development and the capacity to manage distressing emotions and difficult experiences. And we know that trauma can impact virtually all the body's systems. So trauma can be expressed through mental ill health, but also physical ill health. So we have physical symptoms in response to traumatic events, sweating, quick heart rate, but also illness and ill health over a period of time. But it's important and hopeful to remember that even with the most severe examples of trauma, people have displayed extraordinary physical and psychological resilience, especially with assistance. And research has shown that things like psychotherapy can be very helpful with processing, dealing with trauma, EMDR, and any kind of activity that connects the mind and the body. So dance, martial arts, mindful yoga, things like that. So yeah, that's a little bit about trauma and what it is, and how it expresses itself. So looking at the lawyer-client relationship and working with a traumatized client. So a relationship is just that. You are part of that relationship with your client. And you will bring your own life experiences, good and bad, including your own trauma, some of which you might know about, but some of which might be out of your awareness. There's so much of what we experience in life is unconsciously affecting us. And you will bring that into what's co-created between you and your client. We're going to talk a bit more about you at the end, but for now, just focusing on the client and the client who may have experienced trauma. So first of all, there's no hard and fast rules about what you might notice. These are just some thoughts that you might want to hold in mind. You might know about trauma client's experience because they might tell you, or they might not, but you notice some of the symptoms of trauma in your client. Or perhaps you might notice something about yourself and the way you are responding to your client might be kind of a clue there's something going on. So what's common after trauma? Feelings of guilt, shame, disassociation. Might find it difficult to trust someone or to be intimate with someone. Might be self-blame, even when that's incomprehensible, which is perhaps about trying to gain a feeling of control over something that was not controllable. That I've changed what happened. And along with those feelings, there might come some behaviours, because it can be pretty intolerable to sit and live with guilt and shame, for example. So numbing behaviours, drinking to excess, addictions, working extreme hours. How might you experience a client who's experienced trauma? They might be particularly clingy and demanding of you. They might withdraw and be resistant, be uncooperative. You might be on the end of explosive anger. They might find it hard to trust you, and you might be blamed for things that aren't your fault. And in response to that, well, working with a client who is behaving this way can be extremely challenging, particularly when you need to, for example, take instructions on a difficult aspect of their history. You might feel frustrated. You might be tempted to shout back, to withdraw yourself. Well, I'm not going to help you if you can't help yourself. You might feel easily irritated by them or avoidant, or want to kind of avoid dealing with the case. So some ideas on how to approach working with a traumatized client, either because you know they're traumatized or there's some kind of something going on that feels like it's a possibility. So the most constructive advice I can give is to be consistent, reliable, and to use strong boundaries. Don't always be available. Do be available when you say you will be. So don't take a routine call from a client when you're on annual leave, for example, and they know you're going to be on annual leave. Do tell them who they can call and when you'll be back. Be clear about your role, what your job is and what isn't. Feels possible for you to contain and what doesn't. That will be better for you and make things easier to manage for you. Ultimately, it also provides a more secure framework, a structure for the client where they can rely on. They know what to expect, what they can expect of you, and feel contained. Being non-judgmental, be open, don't jump to conclusions about someone's behaviour, and be aware of your own prejudices and assumptions about people, which is something we'll come on to a bit later. I'd just like to very briefly introduce you to the idea of the window of tolerance. So this idea is, if you imagine a scale of, we all have a kind of high zone where we might be hyped up, anxious, angry, kind of hyped up feeling. On a low zone where we perhaps are flat, uncommunicative, and kind of shut down. And in the center of the scale is this kind of window of tolerance, where this is a place where it's easier to focus, feel calm, be resilient, give instructions. tolerate talking about difficult things. And so the things that push it, we kind of, move between these zones, and the things that can push us into the high zone or the low zone can be external. Traffic jam makes me feel angry. A snarky email from a colleague pushes me into feeling low and flat. And if a person has experienced trauma, a window might be more narrow, and they might oscillate more erratically between that high zone and the low zone. High zone and low zone is difficult to kind of have a constructive conference with your solicitor. So you might want to try and help the client stay in that window of tolerance, that middle zone. Just notice if they seem to be veering out of it. Stay grounded and calm yourself. If someone's shouting at you, if they're overwhelmed, don't get drawn in. Don't shout back, but just gently reflect what you can see they're experiencing. Say, yeah, I can see you're really frustrated by this. I can see that I want to watch this video. It's bringing up really strong emotions for you. You might notice that you experience your client's emotions yourself. You might feel really, just have a kind of wave of feeling really sad, or even feeling pain. And just notice that might be theirs, not yours. Say, right, let's take a moment. Would you like to take a short walk? Can I get you a cup of tea? Don't be scared of having a period of silence, and just kind of bring it back to that kind of middle window of tolerance. And all of this becomes easier the better you know yourself and your own stuff, what's going on for you. And that means you can differentiate between what your client's experience and what's your own experience. And we'll come on talk about that at the end. So that's my first section. Thanks very much.
Fantastic, Stephanie. That's really very helpful indeed. Lots to take away there. And thank you for your time on that topic. We will hear from you again later on, where you will finish our seminar discussing how do you as family practitioners cope when dealing with cases that have indecent images. And again, that's going to be another interesting topic for our attendees to listen to. Moving on now to Ayisha Robertson. Ayisha will speak on case law and what family practitioners should be aware of when dealing with cases that have indecent images. So Ayisha, over to you, please.
Good afternoon, all. I hope you can all hear and see me okay. If you've got any issues, just let Stuart know and he'll sort it all out. I'm going to talk us through REM, which is a recent 2002 case. You are going to get a handout after our talk. So I'm not going to give you full citations. I'm not going to take you through all of the law or anything like that. It will be there in your handout. The idea of this talk is just to give you an outline, to show you the direction that REM has taken us in, to provide the definitions and the guidance that REM has given us. I appreciate it's quite a dry subject. I'll try and keep it as engaging as possible. I personally don't like the law, so hopefully if I find it interesting, you'll find it interesting. The first thing to note is that REM is a private law case. However, its principles are still applicable to public law cases as well, in which there are intimate/indecent images. So what we talk about today is as relevant to our private law practitioners as it is to our public law practitioners. I'm sure that everyone that's joined us here today has had cases where there has been sexually explicit images, videos, audio, whatever it might be, where one party or maybe even both have tried to produce in order to prove, disprove allegations. If your experience has been anything like mine, I have yet to find really a case where the inclusion of any of these images, videos, or anything else have really taken us towards any kind of resolution. And in actual fact, my experience has been the use of these images almost as a deliberate attempt, quite explicitly a deliberate attempt in one of my cases, certainly, to humiliate or indeed to continue a pattern of controlling and coercive behaviour, intimidation away from proceedings, intimidation into agreement, or just, again, the suppression of a voice within these proceedings. What I have certainly seen in my own practice is the impact of this sort of behaviour and how traumatising and re-traumatising it has been for my clients and indeed opposition as well. Until this case came out, we had some instruments in our practitioners' toolkits. We have the FPR, which everyone here, of course, is well versed in. We also have, H&N, which has increased our understanding of domestic abuse and how to manage the same within proceedings. But REM really adds quite an important piece of armoury to our overall toolkit. So I'm just going to start with just a little bit of background to the case, because in itself, it's quite extreme. So the proceedings actually originated in High Court. The mother had removed the child M from the jurisdiction to Romania. On the 22nd of January 2020, Mostyn J found that mum had wrongfully done so and ordered her return to the UK. The mother, in fact, managed to return to the UK with the child in time for the substantive hearing, which itself had been born out of the father's application for a joint lives with order, a shared care order, as we once knew them. A fact-finding hearing came about in November 2020, but there is a huge background to the run-up to this fact-finding hearing. Initially, the mother made 3 allegations of rape. She went on and made further allegations of obsessive sexual compulsion, which she considers also a disorder, in which she alleged the father was unable or unwilling to control his desires towards looking at young girls. She said this included schoolgirls. She said the father showed controlling, manipulative and intimidating behaviour towards the mother throughout the relationship. She also alleged financial control, physical violence on occasion. She also said that the father had behaved inappropriately towards the child, encouraging the child for example, to suck his toes, watching him urinate, use abusive language, and recall the child horrible names, and which I won't repeat here, but you can find in the judgment expressly stated. In response to the mother's allegations, the father filed a 31-page statement with an additional 158 pages of exhibits. Of those, there were 32 videos. 17 videos were concerned with 4 occasions about which the mother had produced video material herself. 17 of those videos, he said, demonstrated an entirely different perspective on the couple's sexual relationship to those chosen by the mother. A further 3 videos were submitted, which allegedly showed that the mother was either discussing in positive terms or becoming sexually aroused herself to the various videos, which the mother had claimed were abusive. 10 of the videos exhibited by the father were filmed by the mother and were produced in order to rebut her assertion that she hadn't consented to being filmed and that she'd only filmed sexual intimacy with the father on one singular occasion. The remaining video material was produced by the father to show that the sexual relationship between the parties was not, as the mother alleged, characterised by coercion and control. The court was not told about the nature of this intimate material before it was filed on behalf of the father. And that's, I think, a practical point that I think Delia's going to discuss a little later. But it doesn't stop there. The mother filed no less than 5 statements, and in her 5th statement, it was itself 200 pages long and contained even more intimate material. So the material on anybody's case was voluminous. And I mean, it's interesting to hear what Stephanie has to say about vicarious trauma as we experience through our careers. And one can only imagine not only what the practitioners involved felt like in receiving this voluminous amount of information, but also the judiciary. And I think we mustn't overlook the impact on them also. But anyway, sorry, back to this. Dad's counter allegations were themselves relatively straightforward. He pleaded quite apparently that the mother had wrongfully removed the child from the jurisdiction in the first place. He went on to then allege that the mother had caused the child physical and emotional harm by removing her from her settled home, and also went on to allege that the mother had called the child abusive names. He also alleged that the mother was controlling in respect of his time spent with the child. But the parties again don't stop there. It goes on. At a CMH, the mother alleged a further specific occasion of sexual assault, which was historic and predated other allegations, alongside multiple rapes while she said she was sleeping. She also alleged violent conduct by the father during intercourse, including a non-fatal strangulation. The father pursued an additional allegation at the same stage that the mother has subjected the child to an unnecessary surgery on her labia whilst out in Romania without his consent and against the advice of the child's GP. He also asserted that the mother was fabricating increasingly serious allegations of abuse in order to obstruct his relationship with the child. The fact-finding hearing was heard, as I said, and the mother appealed the outcome of that fact-finding hearing on 2 grounds. I will briefly take you through both, but the second is the focus of this talk. The first was in terms of participation. We all are aware of 3AA, and we all know the duties upon the court to ensure fair access to justice. In this case, submissions were made about the lack of a ground rules hearing, a lack of any appropriate participation directions having been made, which counsel said that this case cried out for the same. The second ground of appeal was that the judge had given insufficient consideration to the possibility that the mother had been over-dependent on the relationship with the father or vulnerable in that relationship. And the judge's analysis of that issue was found to be limited. The appeal obviously was allowed and a rehearing reordered. What happened, interestingly, before the rehearing was the instruction of a psychologist, a Dr. Jones. There was a psychological assessment done of the mother, and he opined that the mother was experiencing symptoms characteristic of complex post-traumatic stress disorder. He also opined that she had a depressive disorder with a comorbid anxiety. The psychologist was confident that the mother did not have difficulties with her cognitive functioning, but did consider that her diagnosis would impact on her ability to provide best evidence. The mother told the psychologist that the past proceedings, so she links her trauma, in part at least, to the trauma of giving evidence in those past proceedings. She describes them as having had put me in a depression. She described herself as feeling broken. She described being cross-examined in relation to the intimate images and the intimate videos, particularly distressing. She told Dr. Jones that she continued to experience trauma-related distress as a result, specifically of her litigation experience, which included psychological symptoms like flashbacks, nightmares, low mood. It was evident, the expert thought, that the inclusion, and I quote from him still, the large number of explicit videos, several large pornographic photographs of her, and several more small stills exhibiting photos, which may not have been actually necessary, all to explore, all did contribute to her trauma. The mother described herself rather sadly as being forever damaged and just simply didn't know how to manage. The expert therefore considered that, well, quite unusually, I think, how this material should be considered in future and addressed within the rehearing. The expert considered that, in fact, within the court setting, the inclusion of this material was likely to have a compounding impact, a compounding traumatic impact on the mother. And he also considered that her exposure to the intimate images and videos or other trauma-related material was likely to impact on her ability to give best evidence in the rehearing. He therefore recommended limiting the number of people who viewed the explicit material. He thought ideally this would be the judge alone. He considered that the judge alone should ask the mother questions about the explicit material, and if further cross-examination was required, that only one advocate be instructed to cross-examine about that material. I think one's got to reflect first at how this case got to the stage it got to. Just in that brief précis I've given you, we can see that the evidence is voluminous. We know that we already have in our army the family procedure rules. We know FPR 1.1 subsection 2 means we've got to deal with cases justly, expeditiously, fairly, proportionately, all proportionate in particular to the importance and complexities of the issues. Ought this case to be case managed much more robustly initially? I would argue probably yes. We know that we've also got Family Procedurals 22.1, subsection 1, which specifically gives the court case management powers to deal with evidence, the nature of evidence, the way in which the evidence is put. That power, of course, is further reinforced by subsection 2 and subsection 4 of Rule 22.1, which gives the court the power to exclude evidence and the power to limit cross-examination. Because, of course, this case was a private law case, of course, the court also had open to it Practice Direction 12J, which again gives it even further strength in with which to deal with allegations of domestic abuse and the sorts of evidence can be omitted and so forth. But interestingly, and most importantly, what we didn't have before REM was any kind of case law that dealt specifically with the use of intimate or indecent images at all. First thing that REM has done was to create a tentative definition of the term intimate image. The second thing that REM has done has helpfully provided us with, the court itself regards it as tentative, but nonetheless guidance as to how such images and such materials should be used in private law proceedings, but as I say, equally applicable in public law proceedings. So I'm going to start with the definition. The definition now of intimate image is, I stress, in the context of private law proceedings, an image of a person, whether adult or child, naked or partially naked. Such an image can include a part of the person's body, clothed or unclothed, such as breasts, genitalia, or the anus, which are generally regarded as private. Intimate images include those of a person engaged in what is normally regarded as private behaviour. So that includes washing, urinating, masturbating, engaging in other forms of sexual act, either alone or with another. The images can be still or they can be moving. Specifically, REM didn't make reference to criminal law definitions. So going into cases, we must be careful to rely only on our private law, child law, REM definitions, not criminal law definitions, as REM did explicitly state it felt it did not meet the needs of the family court. The guidance in particular is helpful. It is 12-fold. It is in your handout, but we are going to go through it. It is actually very digestible, very easily read, and I think probably quite easily disseminated in brevity to some of our lay clients quite easily. So the guidance is as follows. Sexually explicit or intimate videos and photographs should be filed as part of evidence, should not be filed as part of evidence without a written application to the court made in advance. 2, any such application will require the court's adjudication, preferably an already listed case management hearing. I'm not going to expand on those. Delia's coming back to the practical application of this in a moment. It's for the party to make an application to persuade the court of the relevance and necessity of such material to the specific factual issues which the court is required to determine. 4, the court should carefully consider the relevance of the evidence to the issues in the case, together with the probative value of any such evidence. 5, as part of its analysis and balancing exercise, the court will need to consider all the relevant factors, including 1, any issues as to the vulnerability in relation to any of the parties and the likely impact on any such parties of the admission of such evidence and the manner in which it's used to the proceedings. And 2, if it is able to do so at a preliminary stage, whether the application or use of images is motivated in whole or in part by a desire to distress or harm a party. The circumstances, I think I'm on 6. The circumstances in which a court will permit the inclusion in evidence of sexually explicit or intimate videos or photographs of any person are likely to be rare, in particular in circumstances in which that person does not consent to such material being admitted. 7, where a court is being asked to admit such material, the court should consider where there may be a range of alternatives to the viewing of such material. For example, but importantly not limited to, and Riem gives 8 different options here: seeking an admission or partial admission, agreed transcripts and descriptions of videos, playing only the audio track of any video recording, using a still image rather than the video, or short excerpt from a longer video, editing images to obscure intimate parts of the body, extracting metadata as the timing and the location of the evidence, focused and specific cross-examination on issues, and consideration of the use of other evidence to prove the particular fact in issue instead. Of course, some of us are already quite used to using those sorts of alternatives, and the notion of obscuring parts of videos is one that we will often see and when we receive police disclosure and CCTV. So again, something we're not unused to dealing with as practitioners. Moving on to point 8 of the guidance. If the court does decide to admit any sexually explicit or intimate image or video for any purpose, care should be taken to limit the volume of such evidence to that which is necessary to fulfil the purpose for which it is admitted. 9, the court should determine who can view the material that is to be admitted and limit this where necessary, bearing in mind, of course, its private character and the humiliation and harm caused to those both depicted and involved in the proceedings. I assume from that it also means that courts can probably retire, the judiciary can probably retire to see this, to see any videos or images privately without them necessarily being exposed in court for all to see. 9, if the evidence is considered relevant, a starting point should be to say that it should incorporate the lowest number of images seen by as few people as necessary and viewed in the least damaging way. 10, it would be helpful to consider how best to ensure that the evidential security of such material can be maintained, for example, by using only password protected files, both within the hearing itself and outside, and how the material is deployed within the proceedings. Of course, that ties very neatly in with our GDPR requirements as well. And 11, I was one out. I've done what my personal trainer has done. I've lost the ability to count, but at least you get all 12 points. Likewise, the court says specific consideration should be given to the protection and safeguards necessary in respect of any video evidence relied upon. For example, such evidence being made available on a single laptop brought to court, or the distribution being limited to a core specific legal team on behalf of each party, again tying it nicely in with our requirements under the GDPR. In short, this judgment says necessity, proportionality, impact of harm and trauma, exception, not the rule. This judgment is a real tale of caution. And as practitioners, both in court, before the court proceedings, or rather in the initial litigation phases, we should all be hugely alive to the psychological harm which can be caused to our clients and to the other parties if we're the one making the allegations, and particularly to those of alleged victims of abuse, about the use of this material at all, let alone its indiscriminate use, which unfortunately we've all seen in all of our cases. That brings my bits to an end. I'm going to hand over to Delia now, who's now going to put all of that into practice for us and help us all become better practitioners.
Fabulous.
Anyone hear me?
Yeah, we can hear you, Delia.
Good, great. Okay. Hi, everyone. Delia Minoprio. I am a barrister at 1 Crown Office Row. I didn't give Stuart any useful information about me, but I should probably add that I'm the co-chair of the FLBA for Kent and Sussex and the liaison for the Quality Circle for the FLBA. Also, little disclaimer, I have emerged from bed to do this talk, having caught a nasty flu bug off one of my children. I'm on the mend, but on a slightly different planet. So I've asked Ayisha to jump in if I start rambling, more than usual, that is. Okay, so guidelines. My top tip for you to take away, unsurprisingly, would be for you to read this case in its entirety. Ayisha's broken it down for you for a very useful handout, so have a look at that, pore over it if you will. The guidelines are incredibly useful. I'm going to try and pick out specific parts and think about how we might like to apply that in practice for you, whether solicitor or barrister. So let's just geek out as lawyers for a moment here, because this type of law is actually really exciting. It's evolving massively and it's changing. It's really dynamic. And REM shows us that a new judgment can suddenly shift the dynamic for all of us. It's quite complex. And if we sort of stand back and get a bit nerdy, I think we can call these cases fascinating and exciting. It's not so easy to remember that when you're in the thick of it with a client who's going through it, though. So it's going to be really obvious, perhaps it goes without saying, but we do need to think about the advances in tech, how we're all on 2 screens at a time, and our lives are consistently documented through social media on a daily basis for some people. Also people uploading images of their kids, even kids with their own smartphones. So the question of indecent images or dodgy images becoming part of your workload, I would say it is more of a question of when than if. And something James said in his opening about our family wizard, about fake texts, made me think of the very real issue of AI. Consider what artificial intelligence will bring to this area of family law, if it's not already. When we're thinking about indecent images in family law, you're going to be looking at things like revenge porn and sexual history defenses, like in REM. How will AI create more chaos in this arena? It adds a whole new layer of complication for any victims of revenge porn. If your client has any photos uploaded to Facebook, Insta, TikTok, Snapchat, it is remarkably easy for an AI app to create something known as deep fake images. I think they call it that in the US. So it's not that hard to use someone else's face superimposed on porn videos. Now we have these guidelines which we can use and which we can direct our clients to. And so the aim should be really obvious. There's a clear message you can give to your clients from the start, and it's about avoiding indiscriminate use of this type of material. And where these pictures and videos would be admitted and looked at by possibly only the judge, possibly others, those cases are going to be rare. It's also really hard to apply this case practically, because we all know every single case that comes across your desk is different, albeit with similar themes. Like Stephanie said, some of your clients will be amenable to advice, some will be traumatized, some will be difficult. I heard the words clingy, angry, explosive, makes me think of my children. But, it's going to be really challenging, and it will take energy and patience from you to get the message across, firstly about what your instructions are, and then also, of course, about what will and won't be admissible, however hard they insist. I loved Stephanie's tips on how to deal with clients in this state. It sounds quite similar to parenting advice about not matching their mood, acknowledging, stepping back, keep it to the middle window of tolerance. If only I could do that with my eldest. But REM does represent a real change, and these family law cases prior to this judgment almost make Wild West in terms of evidence being admitted without any scrutiny. So I would say a good start when you're with a client on either side is to remind them, first of all, about the court's role. What does the judge care about? It's the child. If your client is a victim of abuse, we will need to remind them with empathy that what the judge cares about is mostly what the impact of that abuse is on the child. Does it amount to significant harm? Is it emotional? This is the sort of thing you need to hammer down with your client when you first meet them and go through it. So when someone comes to you and the issue of indecent images crops up, it's going to be part of your role to help the court control this type of evidence, not just to try and reduce harm to your client and ultimately your case, but obviously, of course, to the children. So if you allow me to generalize in the knowledge that not all cases are going to be like this, but imagine you're for a client, let's say a mum, asserting domestic abuse of some form, possibly unreasonable sexual behaviors, rape, sexual violence as evidence of that abuse. You might need to be thinking about, okay, what is the other side going to come up with? You might need to think about, there might be a sexual history defense used by the other side. And so you might feel bold enough to say to them, look, it's possible that this will come up. What are we talking about in terms of explicit messages you've sent? Are there videos out there? Are there pictures of you out there that you may have shared with each other at one time, used in a consensual way that might come back to bite you on the backside, as it were? So I always like to run the other side's case with your client so that they can be as fully prepared as possible to know, okay, this is what we're likely to come up against. I appreciate that's going to it's going to come at the stage where you've already built that rapport with them, and it's not going to be easy for them to hear. You're saying he did this, he will say you wanted it or it's consensual. You're going to have to encourage them to be open to thinking about what might pop up. It may not, but you really want your client to be prepared for the worst case scenario. And at least now you can reassure them that, if there are these indecent images, if this comes up, there are these guidelines which help limit them. So the first thing you should do, I think, with either side of the case that you're on, is issues of vulnerability. They need to be identified straight away so that the court is aware and can get its head around those practice direction and ground rules. Obviously, we have PD 12J and all of the practice directions that Ayisha's touched on already. You also want to think about the impact of the admission of that sort of evidence. If you're dealing with allegations that your client wants to raise against the other side, be sensible. Try not to. There was over 53 allegations in a case where I was dealing with two mums, in fact, and none of them were found proved. Think about what evidence your client has to back up the allegations. Don't forget to state your case, but you've got to tell the judge, most importantly, what is the impact of that abuse on the child. And then I would also think about talking to your client about the end goal here. Look, what are they actually saying about where the line should be drawn in terms of contact arrangements? Is it realistic? Is it child focused? Or do you simply have someone on your hands who is not going to serve themselves well? It's a really good idea to keep your client with the end goals always in mind. So he might be alleging this, you might be alleging that, but where are we going to get to at the end? What are you saying is the absolute limit? Because I would like to start at the end of the case so that I know what we're going to be saying in our final submission. So you've got to get your client thinking about that early on and encourage them wherever possible to be as child focused as possible. The one who's most child focused and most reasonable, it is the one that the judge is going to get the good gut feeling about, in my limited view. So if you're acting for the other side, let's say it's a dad who wants to rebut allegations of violence or abuse by showing the court images or videos or texts, you'll need to be really clear with them about what these guidelines are from REM, about what will be admissible, and you'll also have to prepare them for having to run that case on these images as a preliminary stage in proceedings, most likely during a CMH. So that's going to be a really difficult conversation. Again, rapport is everything. I mean, I often start conversations with clients at court, reminding them that, you know, it sounds trite, but, you know, I'm not there to be their friend, and some of my questions are going to be difficult, but the greater understanding we have of the case, the better we can fight for them. And so bear in mind, the court is going to be asking, if it can, at an early stage, whether an application for admitting images is motivated from REM in whole or in part by a desire to harm. So that's a huge responsibility for you. You're going to have to get inside of the mind of your clients. You know, if you feel they're not being straightforward with you, and one way that you've probably all got your own excellent techniques for this, but one way that I do it is just a bit of plain talking. You know, why are we saying we want these images? What do they go to? We have to prove to the judge that there's value in these images, in everyone seeing them. What's the relevance? What's the probative value? So keep those questions in mind when you're talking to your clients. And, you know, if you're responding and your client's also making allegations, be bold. You can say, we are seeking findings against the other side, and seek a direction for any schedule to go both ways. If your client is saying the allegations have been deliberately fabricated, say it. Whether or not you're going to have images to back up your case, whether or not they'll be admitted, it's important to get your case down on paper as soon as possible. You can invite the court at an early stage to find as fact that the children are at no risk of physical or emotional harm from your client, even if the ex-partner is saying they did X, Y, and Z to me. So if you are thinking about an application for the inclusion of indecent images, or images that would probably be classified that way, you will already need to be able to run your argument. If you're briefing it out to counsel, I would say you definitely need to have had a full separate con with counsel and your client, probably only on this topic as a preliminary stage, because it's a lot like the other cases where domestic abuse or alienating behaviours crosses over in the process. The admin is the same here. You've got to think about the same things: early case management of allegations, be robust with your clients about what allegations they really want to go for, what the probative value is, discourage using indecent images, save where strictly necessary to the issues at which the court needs to resolve. And as with other crossover cases, you know, you're going to have to think about early on about witnesses, evidence in support of your case other than indecent images, and you'll need to do this with telling the court that an early fact finding should be at the forefront of the court's mind. We know it's not always necessary, but if a case falls like this falls on your desk, sorry, I'm jumbling my words. I'm still with it, Ayisha, don't worry. Do you want to encourage the judge at the earliest stage to think about setting down a hearing? You know, that means you need to talk to your clients about it. Do they really want a fact find? Can one be avoided? Can they afford it? What's going to be? You as a solicitor and counsel as well, you'll have a pretty good idea when you look at the evidence and you look at the schedules as to what is going to be the likely outcome of a fact find. Don't hold back. You've got to tell your clients, because it's going to be quite a lot of trauma to put them through that if you think it's unnecessary. So give robust advice wherever possible. Another tip I've got from REM is to really consider what you are going to include in your client's statements. Okay, so at paragraph 103 of REM, the dad wanted to put in a statement from his ex-wife as to his sexual behaviours, and actually the judge wouldn't have it. But I think the judge hints at how he might have got it in, and points to looking back through all of his statements to see if he suggested that his ex could speak to those aspects at some point if required. He didn't do that. So that's something you might want to do if you're nervous about putting in third-party evidence at the midway point. Mention it all very early on from the first statements. You know, what other witnesses close to the family could produce something helpful. Even if you don't produce anything at that stage, just a paragraph on who can speak to your client's experiences in a more independent way, I think is a really useful tip. Now, one thing that's a huge problem, of course, in these types of cases is thinking about what to do if you're against someone who's in person. It's really difficult. They might be in person and they might not want to engage at all in proceedings. I've had that before. I think I would say handle it like you normally do with litigants in person, but keep the correspondence clear, robust, polite. I've had a couple of cases where judges have actually asked for solicitors' correspondence recently because the solicitors were not being very professional in their correspondence. So be alive to that. I would apply the blush test to anything you write down, which I always do anyway. And in those letters, in those early stages, you can set out the guidelines from this case, which might help and point out if they want to admit evidence such as indecent images, they're going to need to make an application to the court where it's dealt with separately at an early stage. I think, you know, you could do a lot worse than send them the re-en judgment directly, or at least all of the guidelines. Was it 11 or 12? I think 11 points from that judgment. And you always should refer to it in your position statements too. So the court's absolutely got that case in the back of its mind. Another thing that you could do, which actually Ayisha thought about, was you could invite the court on the face of the order that if the question of any indecent images is going to crop up from the other side, it can be recorded that an application will need to be made. Okay, so dealing with litigants in person in these types of cases is going to be absolutely awful. But I think as long as you apply the blush test in, well, what can I show to the judge that I've told the other side here, then you should be safe. In terms of a sort of summary then, things that you need to brainstorm with your clients, I'd say most importantly, consider proactively any vulnerability, special measures toolkits to ensure fair engagement. Think about Practice Direction 3A and PD 12J. 2, think about gathering up information about what might come up, both from your client, and think about what you might want to get subject access requests to: local authority, GP, school notes, police disclosure, telephone records, emails. You've got to think about all of these things right at the beginning. Also think proactively about objective and contemporaneous evidence. Okay, so friends, family, third parties, like I said, maybe even an ex-wife. Keep them relevant and concise where possible. Mention them in your statements early on in case it's something your client thinks about way down the line as wanting to put before the court. Chronology. Get a clear chronology sorted, even if you haven't been asked, even if it hasn't been directed. I really feel like that the person who controls the chronology can wield it to great effect throughout the course of these cases. So it's an idea just to get a timeline down very, very early on that can be produced later when the judge says, oh, haven't quite got a grip on the chronology. Yes, you do. There's one right here. So the last point is really, if your client is wanting to use images like this to support their case, you have a responsibility to discourage it, save where strictly necessary. Okay, and it has to be issues which the court needs to resolve. Think about the impact on the children, manage their expectations, be robust, explain why, run through the guidelines from re-em, and also think about your case in the round. If it goes to fact find, how does it look for your client? What will the likely result be? And good luck. if in doubt, I would get early advice from counsel, although after this talk, you probably don't need any more. But yeah, sometimes I think it's easier for your clients to hear the tough love from someone who is once removed effectively. And also have a think about your own boundaries and well-being. Some of these images will be distressing. You might have your own trauma to think about, get support, think realistically about whether you can manage a case like this. The caseload is going to be huge. And I think Stephanie's going to talk a little bit more about that now. So thank you so much for bearing with me through my delirium.
Thank you, Delia and Ayisha, both excellent. I'm sure all of our attendees found that a very helpful run through for both case law and the practical tips. So thank you both. We now do come back to Stephanie Bell from the Carvalho Consultancy Group, where she will now discuss how do you cope as family practitioners when you are dealing with cases that have indecent images. Thank you, Stephanie.
Thank you. I wish I was that clear, coherent when I was in delirium. Pardon. Right, so what does the research tell us about lawyers? Lawyers who do the sort of work you do are generally pretty resilient, generally able to cope with quite a lot, which is why you stay in the job. You don't leave. You don't run for the first 6 months. But historically, Western thought has separated the emotional from the cognitive, and this is reflected in our legal culture. And what we know about lawyers is generally there's an association of the expression of emotion or acknowledgement of your emotion with a lack of professionalism. There's an emphasis on stoicism, an ability to get on with the job, handle emotionally challenging aspects of a task. It seems to be intertwined with your self-esteem and identity. Our identity as a lawyer is that we can do that without kind of suffering or appearing to. And that, of course, goes along with limited support traditionally. And lawyers typically cope by drinking excessive amounts, humour, maybe some reckless behaviours. Now there's evidence that is changing, the culture's changing, and the ability to use what you experience emotionally in your work being another kind of string to your professional bow is kind of being increasingly recognised. But I'm going to talk about a couple of concepts that have emerged through research that might be helpful for you to frame this sort of work. So one of the terms that's been used in research is dirty work. So what do we mean by that? So originally, at the beginning of this kind of development of this research idea, it was about literal dirty work. So working as a bin collector, cleaning toilets, and the toll of that. But it's now expanded to our understanding of dirty work as proximity to violence, to indecent images. The other concept I want to introduce is the idea of emotional labour. So managing your own response to your client's emotional response and effect is it's weight, it's labour, it's emotional labour. Plus the experience for you of viewing images and videos featuring sexual abuse or violence might provoke a response in you that you have to manage. You're engaging in this emotional labour requires effort, planning, time, knowledge, expertise. It can involve kind of detachment from your own experience of emotion and also controlling your display of emotion, stopping yourself from crying when you see something that makes you feel disturbed and sad. And all of that has been linked with mental health concerns for barristers, for solicitors, including burnout and stress. So dealing with the sort of digital evidence we're talking about, there has been some research into the impact of viewing images, videos of violence, sexual abuse, sexual violence. in the context of police investigators and moderators for Instagram and TikTok, but nothing specifically on lawyers. The first thing we need to do is just acknowledge that evidence like this, being around evidence like this, has the potential to significantly impact you, and potentially on the way you feel about your client. It might provoke sympathy, or sympathy that crosses a boundary, or you might feel alienated from your client when you see some images, and managing that is work. Being adjacent to trauma will often mean you develop your own issues. So things like compassion fatigue, which might result from being repeatedly exposed to pain, distress, or injustice. You're particularly at risk of that if you are conscientious, if you're perfectionist, if you're self-giving. I'm sure describes all of those. It's been described as the cost of caring. Secondary trauma is emotional duress experienced when you're hearing about the first-hand trauma of another. And vicarious trauma is said to occur when professionals working with victims of trauma find their own cognitive schema, that is the kind of framework through which you interpret and understand the world, affected by the cumulative effect of exposure to traumatized clients or traumatic material. Burnout is emotional exhaustion, whereby you might become disengaged and disillusioned by your work. And individuals are especially susceptible to burnout if they are idealistic, have clear personal and professional boundaries, and define themselves by their work, which I'm afraid fits quite well with lawyers doing challenging work like this. Symptoms of burnout include loss of hope, avoidance of clients, colleagues, agitation, irritability, self-doubt, loss of confidence, cynicism, and apathy. And the best advice about burnout is don't burn out. Unfortunately, it's incredibly difficult to recover from. It's really challenging and takes quite a period of time. So I'm going to talk a little bit about things that maybe you can think about, and invite you to just reflect on some ideas that might help. So first of all, emotional detachment and emotional engagement. If you think of them as a kind of scale, so being emotionally detached is here and emotionally engaged is here. You want to be able to contain and understand your client's emotions, but you also need to feel separate from them. And if you think about it, is you're going to be more able to empathize with and understand things from your client's point of view if you're not overwhelmed by the emotional impact of it, which you might be if you're too engaged emotionally. So if you perhaps think about it as being emotionally engaged with the client, but emotionally detached from the material. So notice and establish a boundary between what is yours and what is theirs. So be aware of yourself and what is happening for you. Be a neutral observer of your experience. So if you've done mindfulness, you might know a bit about this. So let's say you're in a conference with a client and you feel a surge of irritation comes up in response to something your client says, or you're watching a video of them with their child and you just feel an overwhelming sense of sadness. So rather than pushing the sadness, you might want to push it down, stop, ignore, or pushing it onto the client. The irritation, you might say, yeah, I'm irritated. They're not listening to me. That's why I'm irritated. Might help just to slow things down and notice what's happening first. So I'm feeling really irritated. Maybe there's something going on for me here. And I might need to think about that later. And then noticing and the debriefing when that client mentioned that I needed help child-wise, I felt a real rush of irritation. Who was that towards? Was it the client or the child? Don't be judgmental of yourself, or just kind of, right, yeah. And just being aware of something happening within you might help you not become as entangled with your client, avoid that. So that's more generally the emotional labour, but more specifically protective factors associated with viewing images or video evidence that might have an impact on you. Some ideas are preparing yourself before, kind of almost like putting on your armour before engaging with the material. Again, neutrally noticing how you're feeling, and being aware that something that might have been like water off a duck's back a month ago is suddenly affecting you today in a way that it didn't before. Be aware that research shows that you're more vulnerable to being really impacted by images where you identify more with the person in the image. So pay attention to that, be curious about it, have privacy when you're looking at this sort of material, but don't be alone. Please don't look at this sort of material for more than 4 consecutive hours. Take breaks, do other work in between, break it up, mix it up with other things, and stop viewing this sort of material, images, videos, at least 1 hour before finishing your workday. So red flags you might notice in the way you are with clients. We touched on this a bit earlier, but feeling frustrated with your client, loss of empathy, alienation, impatience, noticing that you're inclined to overstep the boundaries of how you would usually be with a client, being more available, neglecting in some cases for others, feeling a sense of you being the only one who can help this person, or a sense that you're pretty useless, you can't help this person at all. These kind of more extreme feelings that you might have. What might you notice in life? Feeling helpless, angry or despairing, feeling overwhelmed, feeling cynical about work or the world, and unsafe in the world, not having energy for things you usually like or people you love, intrusive thoughts, disconnection, not sleeping well, your own physical health issues. What can you do to help yourself? It can be really hard working with traumatized people. Being shouted at is emotional labour. Being shouted at is something that lawyers who work with people in challenging situations like you do sort of see as par for the course, but that is really debilitating and can be very affecting. It might be that there's intersection times between your own history and what's happening for your clients, which can make the situation, your response, your client's response, your relationship even more complex. Being adjacent to trauma means you're more vulnerable to vicarious trauma, compassion fatigue, burnout. And as I said, these are very challenging to overcome. So best advice on burnout is to avoid burnout. So you be vigilant, you've got to take care of yourself. You've got to keep an eye on your experience and what's happening for you. And there are intrusive thoughts, for example. The evidence is the best way to deal with intrusive thoughts is cognitive behavioral therapy. And sometimes we can experience things that we're really ashamed of. You know, it feels very shameful, some of the things that are coming to our minds, and when we keep them to ourselves, they can kind of become complex or overwhelming, or feelings we feel about ourselves can become quite difficult. So yeah, see someone and talk about it, and there are really effective ways of dealing with this sort of thing that good evidence to it can be really helpful. So be a neutral observer of yourself, develop that, build up your understanding and awareness of yourself. Notice when something changes and don't ignore it. Notice what works for you, talking about it, distancing yourself, distracting yourself after you've had to look at certain images, or being around colleagues. You have to view the stressing material. It might be that you're able to kind of process it, manage it better in the morning than in the afternoon, all that sort of practical stuff. Make use of your colleagues, talk to your peers, or it might be that seeking professional mental health support is the way to go for you. But both for you and for your clients, we don't always understand the way we respond to things. But I think what I want to say is that it's kind of, there's always help and there's always ways of managing it. And don't suffer in silence. Okay, that's the end of my contribution. Thanks.
Fantastic, Stephanie. Thank you very much indeed. 2 very useful talks in total there. I trust there was a lot for our attendees to take away. Everyone on this link, I'm sure, would have suffered from various forms of trauma in their lives. And talking more about this topic can only help us all. Before we say our goodbyes, if anyone has any questions, please do not hesitate to pop these in the chat now, or do log on and talk to us. We don't bite, so that the panel of experts can look to assist you. Anything in the chat, James? I don't think there is. Okay, before we end, and before anyone logs on with questions, I'm again happy to confirm that the handouts and the recording of this seminar will be sent to you in the coming days. Thank you again to our sponsors, Westgate Chambers, Our Family Wizard, and One Crown Office Road. Any final questions, please? Everyone is silent except one. You're very welcome, Tara. No problems at all. And again, on behalf then of the East Sussex Resolution Committee, thank you all for joining us.